It's just gone 1 o'clock. Good afternoon. My name is Stephen Curtis. Thank you very much indeed for joining us at this Daily Maverick webinar, all about the hot topic of the subject, expropriation. And while it was a hot topic and has always been a hot topic for a long time in our society, the events of the last few days, the intervention, if I can call it that, of US President Donald Trump has certainly given it a lot more heat. 2 weeks ago, President Cyril Ramaphosa signed the Expropriation Act into law. In any country in the world, as you know, the legal processes in which a government can legally deprive someone of their property is going to be hugely contested. But almost all countries, whether they be free market economies, democracies, autocracies, almost all of them have some form of expropriation law. From time to time, a government will need to take some land for some public purpose, usually to build a railway, maybe it's to make an administrative decision in some way, maybe it's to install a power line or a servitude in a particular area. This used to happen in apartheid South Africa, both for issues to do with grand apartheid and the removal of black people from certain areas, or for city planning purposes. It happens in the UK. It happened in democratic South Africa during the last phase of the construction of lines for the Gautrain in Johannesburg. In our society, given our history, there's another factor, which is while there is expropriation for public purpose, there's also been a long debate about another phrase, which is expropriation without compensation. To my mind, this is a different conversation. This is about our history and about how land owned by black people was taken from them by white people through the use of violence. And that, as I understand that argument, is around the restitution of land in some way. This means that in some ways there can be two separate legal issues: expropriation for a public purpose, which can include the legal concept under our law now of no compensation, and expropriation without compensation for the purposes of restitution. Our politics being our politics, this has all become incredibly conflated. And then, of course, Donald Trump being Donald Trump has poured some fuel on the fire as well this week. This lunchtime, we're joined by Bulelwa Mabasa, the director and head of the land reform practice at Worksmans, the law firm. Annalise Crosby is the head of legal intelligence at AgBiz, the agricultural business chamber, representing essentially farmers. And at short notice, we've also invited Brooks Spector, the associate editor at Daily Maverick. Brooks, thank you for accepting our invitation. We thought with the comments by Trump this week, your views would be very valuable. So Brooks, Bulelwa, and Annalise, thank you very much indeed for joining us today. I really do appreciate it. Bulelwa Mabasa, let me start with you. What does this Expropriation Act, the act that is now on the books, that was signed into law by President Ramaphosa, what does it allow government to do it could not do before?
That's a very important question, because I think it centers the debate quite usefully in terms of what is new, what has always happened, and why the hula baloo. I think that what the state could not do before was to expropriate land for purposes specifically of enabling citizens to gain access to land, citizens that were dispossessed of land before. That's number one. Number two, the state was compelled to actually pay market value compensation before, which is known as the willing buyer, willing seller. However, our constitutional dispensation introduced, when it was promulgated in 1997, a different calculation of compensation. So the different calculation of compensation is actually not introduced by the new act. It was always in our constitution, contained in section 25(3), which makes provision for just and equitable compensation. In other words, as opposed to the 1975 Act, where parties could just get together valuations by a valuer, the just and equitable formulation looks at things like the history of the acquisition of the property, the current use of the property, whether there's been any state investment. So it's not just blind to market forces. It forces the state to look at all these other considerations in coming up with a value that could be more or less than market compensation. So I think those are two fundamental ways in which it can be done. But then also, I think quite importantly, the state is now riddled with a burdensome onus of proof in coming to an expropriation, it has got to put together a myriad of reports from a myriad of state departments. In a way, this new act has made it even more difficult, quite interesting and quite ironic, for the state to just expropriate. So in a way, it gives more room for landowners to bargain, to mediate, to arbitrate, to become part of, and to object to the expropriation itself and even the amount thereof. So, and this is very different from other parts of the world where in other parts of the world, expropriation does not need consent from the landowner. But the way that this new act is actually built, and I think it aligns itself with our administrative justice principles of law, is such that the landowner is given far more scope to participate, to object, and ultimately to have access to the courts when it comes to an expropriation.
Okay, so from what you say, the landowner now is in a stronger position than they were before the president signed it into law, in most cases.
There's absolutely no doubt about that. And in fact, the state has to go through some hurdles, I would say about 7 steps before an expropriation can actually take place. And, and along the journey or along the route, you find that the landowner is given powers to object, powers to kind of enter into some kind of an arbitration, and ultimately it's able to do so with the courts being the final arbiters on both the reason for the expropriation and on the amount thereof.
Okay, within all of this, and I think you know what phrase is coming next, there's this concept of nil compensation. Now, nil compensation to me is not compensation at all. Nil compensation is nothing, nada. I mean, it's nix.
Yes.
What is nil compensation?
Interestingly, as a legal concept, which we've borrowed from German law, from the Netherlands, is interlinked with compensation. So in other words, legally, expropriation must always come with compensation. Where it differs is the methodology of calculation in different jurisdictions. But this nil compensation idea is something that has been introduced in this new act, where, for example, once the formulation of Section 25(3) has been calculated, it's possible for no compensation to be paid. So nil compensation is where there is no compensation or something dramatically less than just an equitable compensation. And that is introduced in Section 12(3) of the Act that says that there are instances that may result in nil compensation being paid or no compensation being paid. And those would be things like where the landowner has let the land lie fallow, where the landowner has potentially moved away from the country, where the landowner has abandoned his or her or its responsibility of keeping the land safe, and where there are health risks that are associated with the land. There's also instances such as where, for example, state organs have land on their balance sheets, but they actually don't need to be keeping all that land because they don't need it in order to sustain their core functions in service delivery, and other instances where land is obviously occupied illegally. So think of, when I think about this practically, I think of the inner city buildings that we've seen gone up in flames, that have been hijacked by criminal syndicates. That to me would be kind of the obvious, instance where the Section 12(3) would hit such pieces of land. And the debate, certainly amongst legal scholars, is whether or not the idea of expropriation without compensation is constitutionally sanctioned. The expropriation without compensation that we've seen in our history were the Group Areas Act, the Natives Land Act, where land, people were dispossessed without any compensation. And the framing of the Constitution embedded in it is very much the idea that some compensation must be paid, or at least it must be just and equitable. So the debate in the legal circles is whether or not this idea, then there is a new idea on expropriation without compensation, could pass constitutional muster.
Okay. Annalise Crosby, I'd like you to come in there, please, because, I mean, my political memory, that phrase, expropriation without compensation, is almost about something different. I mean, Valero has been talking about abandoned buildings in the Joburg CBD, for example. We've all seen these situations. Expropriation without compensation nearly derailed the entire ANC's 2017 Nasrec conference. We saw lots of arguments about whether the constitution would change, and that really would seem to be about restitution. Is nil compensation different to expropriation without compensation? And if yes, you're going to have to explain to this non-lawyer why they're different.
I think you touched on the history, and I think it's important to understand how we got to where we are at now. And it started exactly at that 2017 ANC policy conference. I remember reading a piece, I think it was by Mulatsimbeki afterwards, where he said it has never before been part of the discourse within the ANC that there should ever be expropriation without compensation. So that is where it came about. Because of that, there was a whole parliamentary process. There was a motion accepted in Parliament to then look at amending the Constitution not to provide for compensation any longer. So that, from my perspective, would have been an absolute disaster if, in fact, our Constitution was amended, because the Constitution is the supreme law of the country. If you do not have the protection for property and a requirement for compensation in the Constitution, you basically have nothing, no recourse when there's legislation that says that the state can take your property without compensation. But interestingly, the Expropriation Bill, or the attempts to come up with a new Expropriation Act, predates that 2017 debate. There have been attempts ever since 2008 to come up with a new Expropriation Act. And the second round was around 2013, when there was a whole NEDLAC process where a lot of amendments were made to the bill at that stage. And only after the 2017 thing, this was inserted into the Expropriation Bill. Now, the difference, and I think Bulelwa tried to explain, but I can try and maybe explain it a little bit differently, between no compensation and no compensation. When we had those debates, incidentally, about the amendments to the Constitution, there were a lot of legal scholars that said, but the possibility of less than market value or even nil compensation is implicit in Section 25 of the Constitution. Now, if they are right, that would mean that government was actually in a position to offer no compensation even prior to this act coming into force, especially if you take into consideration that there are court cases like the De Tooy case, which is a constitutional case about the expropriation of gravel, that very clearly said that all existing legislation, including the 75 Act, needs to be interpreted in the light of the provisions of the Constitution. So, for example, they would read the public interest into the 75 Act, the courts, even if it only provides for expropriation for public purposes, because the Constitution says we can now expropriate in the public interest as well. But it is important to understand that the end result must be just and equitable, reflecting that balance between the public interest and the interests of those affected. And my view is that there will be very few instances where the courts will find that no compensation is actually just and equitable. And moreover, the expropriating authority will have to be able to justify and quantify how they got to no compensation. So it can't just be a thumbs up. They must show this is how we did the sum and arrived at no compensation, and it is just and equitable in these circumstances.
Okay, so yes, no compensation is there. It's hardly ever going to be used, if at all. Is that what you mean?
I think it's very unlikely. I think, some government departments and state organs might try to test the boundaries of this. And there might be notices issued, but as long as people are prepared to go and test this in the courts, my sense is that the courts will not agree in many instances that no compensation is just and equitable. But they might be, like the example that Bulewa also used, these buildings that are abandoned in the inner cities, that people then just moved into, and it's unsafe and whatever, and it becomes a problem for the local authority. That might be an instance where it might be just an equitable for no compensation to be paid.
Okay. The expropriation without compensation debate is all about restitution. Land was taken, it should be returned to the people who had it before. The Expropriation Act that we're talking about is technically about sort of a public purpose, right? Build a railway. Can restitution be seen as a public purpose? In other words, to put it bluntly, could land be taken from a farmer, no compensation be paid for the purposes of restitution?
Okay, a couple of things. First of all, it's not limited to restitution. We have the free land reform programs, restitution, redistribution, and land tenure reform. Secondly, it's important to recognize that the Expropriation Act is a procedural act. The powers to expropriate are not granted in the Expropriation Act, other than for the Minister of Public Works for the purposes of public works. So the power to expropriate is granted in, for example, the Restitution Act, but there are also powers of expropriation in the Labour Tenants Act and in the so-called Provision of Land and Assistance Act for a very specific purpose. So that minister, in this case the Minister of Land and Rural Development, for the purposes of restitution claim, can exercise expropriation powers, but he can only do so if it is a valid restitution claim. So if the claim complies with all the requirements for a valid claim, and if no agreement could be reached with the landowner. And then once again, in the expropriation process, they will only be able to offer null rand compensation if that calculation, which must be justified every step of the way, comes to null rand.
Okay, I remember Professor Elmine du Plessis just joined the bench now as a judge, an expert on land law, saying to me once that I think there are 136 legal steps to a successful land claim. I presume that's still the case. Each one of those can be challenged.
Yes. Well, I don't know if each one will be challenged, but it's very difficult because you have to sign with the Labour tenants. You have to prove it's a valid claim. Then only if there's no agreement with the owner can the minister expropriate, and then all these steps that Bulewa was talking about for expropriation need to be followed.
All right. Just a reminder, thank you for being with us for this Daily Maverick webinar about expropriation and the Expropriation Act that was signed into law by President Cyril Ramaphosa, and all of the matters that may follow that. And many of the matters that came before. There are places for you, and there is a space you'll be able to see to write questions. They will be sent to me. I'll put them to our guests, and we'll continue the conversation from there. Brooke Spector, you've been very patient with us. Thank you. We saw President Trump's warning this week that he would cut foreign aid to South Africa because of expropriation and land issues. He spoke about I think the quote was a particular class of people. I presume he meant white people. Why did he do that? What's in it for him?
Good afternoon. Good to be with you on this. What's in it for him is a little vague, but we have to remember that this is not the first time he has intervened vocally on land and South Africa. Back 2018, I think it was, when the act was publicly being debated but not yet promulgated. He responded in a similar way, and this appeared to be at the, he was prompted effectively by a number of people who showed up on Tucker Carlson's broadcasts. At that time, Tucker Carlson was fairly right-wing or very right-wing, depending on where you sit, I guess. And he went kind of quiet for a while because Donald Trump wasn't president after a while, but now he's back. And almost immediately after taking office, one of the first acts that he issued as an executive order was to put a hiatus, a pause, on all foreign assistance from the United States everywhere, with the exception of emergency humanitarian assistance and ongoing aid to two Middle Eastern countries, Egypt and Israel. And then in the process of doing that, they began to disassemble the actual agency that organizes, manages, and monitors foreign assistance from almost all US programs. It appears, to me at least, that Donald Trump has been energized in this regard yet again by the promulgation of the act, as well as his increasing dislike for foreign assistance, and in addition, the efforts of Elon Musk, a name that needs no introduction, in his effort to cut back the federal government by some major amount and cut back funding by some equally major amount. And of course, one of those areas that's fairly easy to cut, although it has minimal impact, is foreign assistance. It's about 1% of the budget. So it's not going to make a difference in that sense. The end result, of course, is this has provoked something of a he said, she said between Donald Trump and Cyril Ramaphosa, and the local president quite clearly came out the more adult and more mature in the exchange.
Brooks, I hate to be so cynical, but it would seem to me that if we, it would seem to me that if you look at the way that Trump has campaigned, a lot of it is about the issue of race in the United States. And is he not suggesting to white voters that he'll protect white people everywhere? When he talks about a particular class of people, I mean, that's what he means, right?
Yeah, I don't think you're being cynical at all. I think you're simply being observant. That was most of his supporters are white Americans who, for whatever their particular reasons, felt aggrieved with the government and with the policies of the country. They were fearful of some sort of great change that was happening. And one of the expressions of this, for Mr. Trump at least, is to search out and destroy any evidence of this kind of thing anywhere. And in this case, of course, it's, all right, you've passed your law, and just in response to that, because of the way you're carrying your political circumstances out, we're not going to give you any more foreign assistance. Make no mistake about it, though, most of that foreign assistance goes to PEPFAR and related health programs. There's very little, well, there's a little bit in other areas, but that's about 2/3 to 3/4, depending on how you count it, of all the American foreign assistance in South Africa these days. And preferentially, the people who benefit from it are people who don't have great power, wealth, or position. They're people who are either at risk to having HIV and AIDS or already do. But that doesn't seem to matter very much to Mr. Trump, and it doesn't seem to matter very much to the people who support him. And it quite clearly doesn't matter very much to his new Secretary of State, Marco Rubio. And in fact, many of the people who work for USAID, the aid agency, have now either been put on leave or locked out of their offices as the institution itself is being essentially assimilated into the State Department, so there can be direct policy control over every penny that seems to be spent. As I'll sort of tie this off by saying that Cyril Ramaphosa, in his response, tried the now, Mr. President, you know, there's lots of good things we can do together, and we should build on our relationship. We shouldn't let the small things divide us, which, given the circumstances, was a pretty adult response.
Brooks, thank you. All right, we have plenty of questions. I have more questions too, for Brooks, for Bulelwa, and for Annalise. Bulelwa, this will come to you. This is from Taryn Harris. Taryn says, courts are cumbersome, they're slow, they're exceptionally expensive in this country. To test this, one would need to have the funds, the time, and the ability. And several other people have followed up on Taryn's point. I think it is an important point, Bulelwa, where someone knocks on your door, says we're going to expropriate your land. I mean, to fight this, you'll need just at the start, you'll need to know exactly what you're dealing with. Then you'll need to hire a lawyer, etc., etc., etc. I mean, it is an important point in this. You would need money to fight this off.
Yes, and I think that speaks to access to legal representation, good legal representation in South Africa. I think it's not a debate that legal services are incredibly expensive, but I think what the Act tries to do, and I mean, this remains to be seen whether or not it will be useful, the introduction of a mediation process where there is an independent mediator who is not going to charge fees, is a manner in which, or at least an attempt at trying to assist those that don't necessarily have access to legal services. Mediation by its own nature isn't riddled with the same cost as a cost of a lawyer. What remains to be seen also is whether or not the state will provide mediators that are independent, that are able to assist, Joe Soap for purposes of this. So it is true that by the time that one requires, legal advice or an attorney or an advocate, it's so far down the line because the mediation process, that's followed by the arbitrator process, is designed to avoid that laborious, expensive, and time-consuming type of litigation. Okay, and of course, I think what's also important in our country for a lot of indigenous people, especially in land matters, there is the legal aid system where people can rely on, the state lawyers to assist them. But as I've seen in practice, many of the legal aid system simply cannot take the burdensome demand for access to legal representation. And I think that that's where things, places such as public interest firms, pro bono legal services would have to be kind of bolstered for purposes of assisting those that do not have access to legal representation.
Look, if a test case comes along, I'm sure that political organizations will get involved too, I have no doubt. Annelies, I'd like to put this to you. It's a very interesting question. It comes from John Wade Smith. John, thank you. It says, if the Act provides landowners with more legal security, what specifically is the Act designed to address? So what is the problem that this Act actually fixes beyond just creating headlines? Annelies, if I can put that to you, if you consider that all of the sort of political traffic has been moving towards no compensation, and as Blair was said at the very beginning, this actually strengthens the landowner, then what's the problem the Act is fixing?
Yeah, if I can just quickly weigh in on what Bulelwa commented now on the legal cost, I think that is a very real concern. And we had lots of debates in NEDLAC about that as well. And ultimately, if you cannot reach agreement through mediation or any of the other processes and you need to go to court, it is expensive. So that is a concern. There is a court case, the so-called BioWatch case, that said if somebody's defending their constitutional rights, they shouldn't have to do so from their own pocket, but you'll only be able probably to recover the costs, after the fact of the court case. But sorry, that's not your question. We need to remember that this is a procedural act mainly. This is not a land reform act. It's not an act that grants powers of expropriation, like I said, to anybody other than the Minister of Public Works. It sets the procedure for expropriation. And because the 75 Act predated the Constitution, we needed a new law that was in line with the Constitution. So I think really the main aim probably was to streamline all of these procedures, to bring it in line not only with the public interest, but also with the administrative law requirements that the Constitution brought in. Okay,
so there was a sort of legal constitutional problem that it fixes more than anything else. Okay, thank you. Carla Budrix asks, Carla, thank you. What impact does this have on mortgage bonds and other rights on the property, user rights, etc.? I presume if it's expropriated, the user loses their rights. But Bulelwa, if there's a bond on the property, for example, it clearly hasn't been abandoned. There would also be a market value to it, and fair and equitable would have to apply, I suppose. But it's a great question. What impact does this have on mortgage bonds, Bulelwa?
So what's very important to note about the Expropriation Act is that it only applies to land. there is an exclusion that it does not apply to mortgage bonds. It doesn't apply to other residual owners of property over that land. So if I can give you an example, the highest form of ownership on land is ownership. It's having a title deed. But there are other people who could have residual rights over that land, such as a tenant, servitudes, mortgage bonds, and the like. This act is not designed to expropriate anything other than land, even though the Constitution says land includes property. But in this particular act, only land can be expropriated. So those mortgage bonds are not part of what is envisaged here. And in fact, in instances where there is a mortgage bond or whatever, the state will have to settle all of that. But the destination, or where we're trying to get at with the Expropriation Act, is an exclusion of other types of rights, property rights, and only just limited to land.
Stephen, I have a bit of a different take on that.
Yes.
The bondholders do have a definite interest. And because of that, they have been included in all of these steps. So even the initial notice of intention to expropriate must be served also on a bondholder and anybody with a registered or an unregistered right. And the Act requires that all those registered and unregistered rights must be compensated for if they are also expropriated, because in some cases they will. And then ultimately, there's a clause that says that if there is a bond over the property and the compensation is then finally agreed, then the owner and the bondholder must agree also on how this is going to be, divided. And if they cannot reach agreement, then the court must decide.
Okay, so at least
it's a notification duty. So it is a notification duty, but the objectives of the Act are not to expropriate other types of property other than land. Yeah.
Okay, so my house is going to be expropriated for various reasons. I still have a bond in my house. Then does that mean that the people who I have the bond with, FNB or ABSA or Capitec or whoever, they have to be a part of the process too?
Yes.
They would be allowed.
They have to be notified. Yes.
Yeah.
But I think on the idea around no compensation, and if you look at the 25-3 formulation, the land that has productive use, that is residential, where people are occupying it, and that serves a specific purpose, you would assume, and really this is the intention of the Act, that that's not what is land that is suitable for an expropriation in the first place, but also expropriation without compensation. So I think that's an important point to make, that the expropriation without compensation debate has to be framed around what is the current use of the property, what purpose does it currently serve, in order then to place it as something that is not destined for an expropriation without compensation.
Okay, that makes sense. I mean, it would seem to me very unlikely that any property that has a bond over it would be expropriated in the first place for various reasons. Brooks, this is one for you, and a question that's actually been troubling me a little bit. This is from Jeremy Chapman. Jeremy, thank you. Brooks, Jeremy writes, is Trump's action not merely a warning shot, a shot across the bow, due to our membership of BRICS and our cozy relationship with Iran, etc.? And I mean, doesn't Trump have multiple objectives here, and one of them is to get us away from BRICS, and isn't that what he's trying to do? Is this part of that?
Well, your questioner is right in a particular kind of way, that there clearly are a variety of things, a variety of policies that irk the president and his closest team members, not the least of which, of course, is South Africa's relatively cozy embrace of Russia and its reluctance to oppose Russia's invasion of Ukraine, and in fact to participate in military exercises with Russia and China. Similarly, a close relation with Iran provokes responses as well. The International Court of Justice effort, my reaction to this is was relatively low on the totem pole of irritations because it was assumed that South Africa would do something like that. But the relationship with Russia is all voluntary and exceedingly obvious and visible. Ministers of defense going to Russia to celebrate the Armed Forces Day and so forth, and joint military exercises on the anniversary of the launch of the invasion of Ukraine and so forth. But I suspect also, although I think most Americans in the policy-making world who still have some influence do not hold the idea of BRICS as a major international challenge to America's place in the universe yet, certainly. 10 years from now, I mean, who knows? But at this point, at least, after all, BRICS has no headquarters. It has no actual formal organizational process. The membership continues to expand with countries that democratic societies might not like necessarily to be associated with. And I think BRICS is low on the totem pole of irritations. The other things I think are much more central to the issue. But we can't forget also, as we talked about right at the beginning, that the effort is to how shall we say it, to respond to the complaints that white people are under threat in South Africa. I was trying to find another way to say that, but
no, it is about that. Yeah.
I mean, there is that element to it as well. But, and I'll just add a footnote, Donald Trump is kind of a low information policymaker. He hears whoever speaks to him last is the person who gives him the right place to start with something. If it was Elon Musk, that's one thing. If it was Marco Rubio, it was another. If it was yet another person, be a different direction. And I'm not absolutely convinced that this hold on aid, foreign aid generally, or hold on aid to South Africa specifically, is going to last much more than a couple of months while they go through the show trial of trying to figure out whether aid is in the interest of the country.
Okay. Lekhanyane Moke has a very interesting question, which Annelies, I'll probably start with you, but if Valeria would like to chime in as well, be very happy to hear from her. Lekhanyane writes, how are we going to be affected? We have claimed a piece of land. It's in the Moratele local municipalities, portion 3, it's Wildebeer scale. This is in the Bojanala district in Northwest. So the claim has been in since 1998. There's been no progress from the Northwest Land Claims Commission. Annelies, I mean, does this affect any claims that are currently in the works? Does it change how they're dealt with, or does it have nothing to do with them?
I don't think it should really have any impact, unfortunately, because like I explained before, you first have to prove the validity of your claim, and then there are lengthy processes. Often there are contending claims over the same properties, or there may be disputes within the community that is claiming or whatever. So restitution claims, unfortunately, do take a very long time to get to finality. And one can absolutely understand the frustration. But it's not necessarily the actual purchasing of the land that is delaying. So one would need to understand what is delaying it. As the claim, is it considered to be valid? Has it been gazetted? Or have the disputes been resolved? Or the business plans for how the land is going to be used and all of that? So, they'd have to establish what the cause of the delay is. All that this now really does is it clarifies the procedures if the problem is that the landowner is not willing to sell, they can't reach any agreement, they want to go to expropriation, the process is now clear.
Okay.
I think
right.
what I'd like to add there, Stephen, which is quite important, is that the land claims process is dealt with by a completely separate piece of legislation, which is the Restitution Act. The Expropriation Act has nothing to do with the lodgement of land claims. The person who's asked the question has a restitution claim, and that is a specific land reform process which the Expropriation Act does not unfortunately deal with. The only relevance that the Expropriation Act would have is if the claimed land is subject to an expropriation because is it in the public interest. But I think it's important to highlight that there shouldn't be a conflation between expropriation, which is a public administration tool that governments use to acquire land, and land reform objectives, which are completely dealt with by different pieces of legislation, such as the Restitution Act, Labor Tenants Act, Extension of Security and Tenure Act, and so forth.
Okay, no, that makes sense. Thank you, Bulelwa. Bulelwa, while we have you, Mari Labaskachni asks, the definition of public interest and public purpose can seem rather vague. What are the measures that determine that, and how will the state ensure that those purposes, and Marie, if I may speak for you, I think you might mean only those purposes. So
yeah.
How do you define public interest and public purpose? And I realize that there might be a time when a lawyer acting for government wants to broaden that definition.
I think those are actually quite benign terms legally, in a sense that a public purpose is self-evidently a state hospital, it's self-evidently a state school. So it would be very difficult for government to argue that something is in the public purpose, it's for a public purpose when it's not. You mentioned the Gautrain. That is quite obviously something that is part and parcel of the public purpose. Public interest, on another hand, is made provision for in our Constitution in Section 25, which includes the nation's commitment to land reform. So actually, the state doesn't have much room to maneuver or to say something is in the public interest or in the public purpose without it being so, because those terms are actually quite, they have, a very specific application in our law. So it's not, and as I said, no expropriation can actually come to be concluded without its purpose being sanctioned. And so the state has very little room to argue that something is in the public purpose when it isn't, or even in the public interest. The public interest would be land for restitution purposes, or land for redistribution purposes, for example. But and it has to show that that is indeed the case. So as I said, I think this as much as it sounds like it could be subjective, I think it's very possible to objectively apply the test whether something is in the public purpose or in the public interest, given our legislative framework.
Right. Okay. So Annalise, we have an election. Jacob Zuma becomes president again. He appoints as his land reform minister Julius Malema. And Yanni Moolman puts it in this way. He says, is the main fear of this act not the fact it may be open for abuse, but it could be used for political purposes rather than a real public interest. And Yanni's put it in a very interesting way, but isn't that the concern? So what would stop government from that? And I'm presuming it would again be the courts and the definition of public interest, and that's where the argument would stick, Annalise.
So ultimately, it's the courts that have to apply the Constitution. So people need to be prepared to go to court. And hopefully, like you said, people will be supported in test cases, because it is important to get clarification from the courts on some of the provisions that are not all that clear. But as long as the Constitution remains unchanged, as long as we can still rely on our courts to bring justice and be objective, and as long as you can find a way of paying for your court case, that is ultimately the protection that you have.
There was a question a little earlier, which I thought was a fascinating question, actually. And it was around, why is it wrong to actually basically target land that's being used for speculation? So as I understand it, the question is that at the moment, the law is very specific that says, here we go, it comes from Makone, thank you. Why is the de facto criminalization of land speculation, where the act permits nil compensation, justifiable? Why punish speculation in the property market and not others? For example, in the stock market. But anyway, it's an interesting question. So the act, as I understand it, is specific about land that's being held for speculation purposes and not being used. Isn't McConnell onto something? Isn't it being sort of criminalized in a way?
Interestingly, the previous draft of this expropriation bill specifically mentioned land held for speculative purposes. This bill does not have that wording. It's worded differently. To say, for example, where in the case of the state, it says where the state doesn't need the land, for its core purposes. I think the wording of it in this current act is softened. It doesn't say it was held for speculative purposes. So I know, for example, that the property sector of the economy sometimes will purchase land and not necessarily use it immediately because there's still, processes that it needs to follow, the rezoning and so forth. My view is that kind of land, it doesn't fall within the remit of what is intended here. Rather, the act envisages land that is almost kind of abandoned. You can't find the landowner. But I don't think that the property market, in how it works, where, for example, land is being bought, but it can only be used in 3 years after zoning or all of that. I don't believe that would be falling within the expropriation without compensation debacle, because that land would have been acquired with value. So the landowner, the property company would have bought it for a price. They would be able to demonstrate that they have a purpose for the land. They will be able to demonstrate, hopefully, that the land is productive. So I think there's a way in which, based on the facts of each case, and such as the example that I've mentioned to you now, that would assist a property developer in not being, kind of brought within the remit of expropriation without compensation for those reasons.
Okay.
The wording currently I see where the land is not being used and the owner's main purpose is not to develop the land or not to use it to generate income. And I think in the farming context, that would hardly ever happen because farmers use their land. But for other developers, it might be a bit problematic.
Alison Skuman asks, what about RDP or student accommodation? Wouldn't that be considered public interest or public purpose, Annelies? I mean, I think that let me say what I think, and then I'll let you speak if I may. Because of what happened in Zimbabwe, because of the political rhetoric from political parties, and because of what we've seen around former President Zuma and Julius Malema and now Trump, there's a great deal of distrust. So even though we have the Constitution, even though we have a law which appears constitutional, even though we have judges which have ruled against government many times, there is still a level of distrust, and that's partly to do with our history. It's partly to do with what happened with the courts in Zimbabwe, etc. So that is why I think we get questions like this, and many of them are absolutely legitimate. If the last 10 years have taught us anything, it's to not always trust our government, and if apartheid taught us anything, it's not to trust that government either. So that's why we're getting so many of these cases. So back to Alison's question: could student accommodation or RDP housing, or we're going to knock your house down, we're going to take it from you because we're going to build a block of flats here because it'll house more people and you're close to the Joburg CBD. Isn't that a legitimate public purpose?
Yeah, so I can fully understand people's fears. And I think what we do need to remember is, like I said, the power of expropriation must be granted in a particular piece of legislation, and it must state the purpose of expropriation. So if there exists some legislation at local authority level that says that the local authority can expropriate for housing purposes, that would likely be a public purpose rather than in the public interest, although one can debate that. Then that is a possibility, but it will only, there's a distinction in the Act. The Act covers all property. and all property can in principle be expropriated if in another piece of legislation provision is made for it. But that no compensation clause relates only to land that gets taken in the public interest, land reform, and it's only land, it's not all property. So yeah, it's not impossible, that kind of scenario, but you would require the legislation that provides specifically for it, and you can test it in the courts once again. If we can't rely on our courts any longer, then we're in deep trouble.
Well, then, yeah, nothing else matters. Land has no value anyway in that context. Brooke Spector, I think a question that many people have been asking, and I've certainly been asking myself, is how is it that AfriForum appears to have had such an outsized impact? Now, AfriForum, yes, it's a very well-run organization. It's very professional in what it does. It has a very specific purpose. It does not speak for the majority of South Africans. And I think I can say that with no fear of contradiction. How is it that this organization, representing a minority within a minority, had such a big impact on American foreign policy that we are all talking about this now?
Fascinating question. I mean, you puzzled over it, and I suspect I have too for a while. I think part of it is that they are talking to people who already have a presumption to hear sympathetically what they're saying. And they are playing to a larger rhetoric, a larger universe of thoughts that people like them, and that's language out of the Trump handbook for sure. People like them are under threat by the others, and we all know who the others are. What this means in practice is that when they say something and they make a well-reasoned case, whether it's based on fact or non-fact, there's a willing presumption to say, yeah, interesting. It could well be true. It might well be possible. We might well believe that. And then what follows inevitably from that is, what do you do about it? And in this case, we know what was done. A hiatus on foreign aid directed to South Africa within the larger picture of aid to all countries, basically. One of the other questions that you got, which sort of builds on that a little bit, somebody is asking, how much aid is it, and why? What is it for? Well, the latest figures I could find from last year, it was about $323 million. Somewhere around 2/3 of that, or a little bit more, depending on how you count it, went to public health, most especially HIV and AIDS and related questions. And then there were a few other things. And if the numbers are right, that represents about certainly under 20% of the total PEPFAR budget in the country. But it's a significant enough amount of money to be concerned about. But again, to go back to the original question, if there's a willing presumption to believe people who look and sound like you are saying something that's truthful, and you have all the evidence to the contrary from the Zumas and the Malemas and so forth, that's where they're going to land, I guess.
Okay, no, that does make sense. Thank you. And I suppose if Kamala Harris had won, they would have had no influence in the end.
Pretty much, because they would not have gotten into the front door. And I don't think Kamala Harris's people would have listened very much to Tucker Carlson in his discussion programs, and AfriForum and related bodies probably wouldn't have gotten appointments at a high level to talk to anybody.
But anyway, it seems to me, if you are looking at, one or two people have made this point, if you are looking at land that is unused, virtually abandoned in this country, a large amount of that land will be owned by state entities. A very large amount. Depending on which number you believe, around 1/3 of the land in South Africa is owned by the state. There are lots of different ways of looking at that, obviously, and it'll be contested. But I would presume it would be that land that would probably be sort of, if we were going to do a proper restitution process, or a proper process of giving people access to land, people with nothing access to land, that's the land that would go first, right?
Yes, that would make sense. Stephen, especially because from state to state, the state doesn't lose out anything, if you think about it, when that land is abandoned. And I think what we've seen actually in the last 30 years is a state reluctance to use its expropriation powers. Whilst, of course, we've seen it happen in terms of Gautrain and the public purpose and roads, we've hardly seen it happen in the context of it promoting land reform objectives. So it does have a legitimate potential purpose of progressing land reform objectives. And, we've got to see the political will in doing so. But I think it's not just going to depend on the state implementing the public interest abilities. It then also talks to land tenure. So, for example, the majority of people in this country don't have formally registered or registrable land rights. A deeds registry is still excluding about over 70% of people with land that don't have title deeds, they don't have lease agreements. We're still using policies where when the state does give, for example, emerging farmers land, it does so sometimes without a lease agreement, sometimes they give them a 30-year-old lease. So whilst, yes, there is some room to maneuver where the state can purchase its own land, or not purchase its own land, but give the land for land reform objectives, that is not going to be the magic bullet, because you still want to make sure that those people who are restored with land actually have strong tenure rights that are registered, that are going to form part of the deeds registry, and that people can trade on.
Okay. Annelies, so we now have the Act. As I understand it, after the Act, it's been signed, it gets proclaimed, then regulations have to be drawn up. And the regulations are drawn up by the minister who is in office at the moment, who is Dean McPherson, who's from the Democratic Alliance as the Minister of Public Works and Infrastructure. Does he have much latitude? I mean, could he say in the regulations no property will be expropriated for nil compensation? I mean, I presume the expropriation cannot contradict the Act.
No, certainly the regulations have to be in line with the provisions of the Act, and the minister can only make regulations that the Act specifically allows him to make. And I had a quick look at things like the forms and anything that is prescribed that needs more clarification. It's actually quite limited, the regulations in terms of this particular Act.
That makes a lot of sense. We could go on forever. I suspect that we probably will when it comes to land in South Africa, because of the historical reasons, because of the very important and difficult history that we've had, and because of the person who currently sits in the White House. I'd like to thank you all for being with us today. There'll be more webinars like this as well, probably more on expropriation to come as well. Annelies Crosby, the Head of Legal Intelligence at the Agricultural Business Chamber, thank you very much indeed for being with us today. Balewa Mabasis, the Director and Head of the Land Reform Practice at Worksmans, the attorneys. Balewa, thank you. And Brooks Spector, Associate Editor at Daily Maverick, I'm sure soon to appear on a television or radio channel near you, talking about what's going on in the United States. Brooks, thank you very much indeed for joining us. Thank you for being with us and for being part of Daily Maverick. And if I may just say, I realize how difficult issues around land are. I realize how little trust many of us, we have in government. I understand the reasons for that. May I suggest, in the conversations that we have around the braai, around the family dinners where politics in the United States can no longer be discussed, maybe just propose this principle, that if everybody spends at least 5 minutes a day reading something they disagree with and go from there. Maybe it'll make the arguments worse, but it'll certainly make them more interesting. But I think that's what the point of Daily Maverick, if you like, or one of the points of it. Thank you very much indeed. I do appreciate it. Goodbye.